joining us today for our webinar on Kentucky's new emergency regulations for hemp-derived products. With these regulations, Kentucky has moved from being a state with minimal regulations regarding hemp-derived cannabinoids to a complex regulatory scheme governing the manufacturing and sale of these products. For many, this transition is overwhelming, daunting, and likely frustrating, and we are here to help. Today, we are going to go through an overview of what the emergency regulations say, along with what their timeline and process is. We will also be giving a brief overview of the federal history of hemp legalization, the Kentucky history of hemp legalization, litigation surrounding hemp products and regulations, trends in state regulation, and prospective changes in federal law. But before we get started, we wanted to go ahead and introduce ourselves. Stephanie, could you move to the next slide? My name is Kristin McCall. I'm a partner in Dentons' Louisville office. So here in Kentucky, I am primarily a litigator and I focus on commercial litigation. But over the past 2 years, I have also been engaging in cannabis law, and both on the litigation side, so doing administrative appeals, products liability cases related to cannabis, etc., but also helping advise clients on cannabis laws and local and state regulations.
My name is Hannah King. I am located in Dentons Portland, Maine office. I am a partner in Dentons National Cannabis and Hemp practice. I've been advising clients on hemp and cannabis laws since 2015. I've been full-time in the space since 2017. I represent hundreds of companies that are operating in the space. I advise ancillary businesses, financial institutions, insurance companies. I also work with tribal governments in both regulating through their sovereign capacity, but also in entering into the space and partnering with business partners, both for hemp and for cannabis.
And I'm Arin Aragona. I'm a partner in the corporate and cannabis groups in the Louisville, Kentucky office of Dentons. I've been working in the space since 2016. I recently, within the last few months, joined Dentons after being general counsel of a private equity firm that was focused on the cannabis market nationally. It was based out of Greenwich, Connecticut, and we invested a couple $100 million across the United States into the cannabis industry. So I've been doing cannabis work full time since 2016.
Thank you, Stephanie. So now we can get started. So before we dive into kind of the new hemp law and hemp regulations in Kentucky, I'm going to set the table a little bit by talking a little bit about the U.S. hemp market, about federal regulation of hemp and regulation of hemp in Kentucky. So there is not a ton of data on the hemp-derived cannabinoid market, and there's two reasons for that. One is this is an emergent market that has exploded in the last 18 months. In addition to that, it's grown in this kind of unregulated void, and so it's very difficult to track. That said, in the fall of this year, Whitney Economics released the U.S. National Hemp-Derived Cannabinoid Report. And in that report, they estimated that the U.S. market for hemp-derived cannabinoids in 2022 was $28.4 billion. So according to the report, that's larger than all the state marijuana markets in the country. It's also roughly equal to the size of the craft beer industry nationally, which obviously is a well-established and mature industry. Additionally, according to Whitney Economics, the hemp-derived industry employs over 300,000 workers, that those workers earn around $13 billion in wages annually, and that it has an overall economic impact of $79 billion. So I would encourage everyone to kind of take these numbers with a grain of salt. But the reality is that this is a significant market. And even if these numbers are close, hemp-derived cannabinoid products in a very short period of time have become a significant economic driver, and one that both the federal government and state governments just simply can no longer ignore. Next slide, Stephanie. So just briefly, the federal history of hemp legalization is that in 1937, Congress passed the Marijuana Tax Act. It very broadly defined marijuana to include both low delta-9 THC hemp and high delta-9 THC hemp, so cannabis, so covered hemp. It prohibited the sale and possession and use of marijuana for recreational purposes. It allowed use of sale of marijuana for medical purposes, but imposed significant taxes that essentially made it a non-viable market. In 1970, Congress went even further in passing the Controlled Substances Act. It classified marijuana, again, very broadly defined, to encapsulate both what we know of today as marijuana and hemp, as a Schedule I drug. Schedule I drugs are the most dangerous drugs. They, according to the Controlled Substances Act, do not have any kind of recognized medical value. And there are significant criminal penalties associated with the production and sale of Schedule I drugs. In 2014, in reauthorizing the Farm Bill, Congress did not carve hemp out from the Controlled Substances Act. It continued to be a Schedule I drug, but they did authorize states through their departments of agriculture or financial or institutions of higher education to run pilot programs on the cultivation, manufacturing, and sale of hemp. In again reauthorizing the Farm Bill in 2018, they carved out from the definition of marijuana in the Controlled Substances Act hemp being defined as cannabis sativa L with 0.3% or less of delta-9 THC on a dry weight basis. So in signing the Agricultural Improvement Act of Farm Bill in 2018, hemp is no longer a Schedule I controlled drug. However, the Farm Bill did say that the cultivation and sale of hemp had to be pursuant to USDA-approved plans or a license issued by the USDA if a state did not want to regulate hemp itself. Within days of the 2018 Farm Bill passing, the FDA issued guidance saying we continue to have jurisdiction over hemp, and that because cannabinoids in hemp, specifically CBD and delta-9, are primary ingredients in approved drugs, it is a violation of the Food and Drug Act to introduce into interstate commerce any consumable product or dietary supplement that contains these substances. And that continues to be the FDA's position today, that it is a violation of the Food and Drug Act to sell over state lines food products or dietary supplements with CBD, hemp-derived delta-9, and hemp-derived delta-8. There's been very little enforcement. Every 6 months or so, they send out some cease and desist letters, and that's about it. The other thing that the Food and Drug Administration did is, for a number of years, they were signaling that they were going to develop regulations to kind of regulate. Folks were thinking probably similar to dietary supplements, the production and sale of non-intoxicating CBD products. Earlier this year, they announced that they had concerns about the safety of CBD, that they felt prohibited them from regulating CBD products under the Food and Drug Act, and that it would require direction from Congress in order for them to impose regulations. So right now, hemp is no longer a controlled substance. There are the states have kind of been left to regulate the manufacture, production, and sale of hemp and hemp-derived products. Next slide, Stephanie. And Kentucky has always been a real leader in the hemp space. So in 2013, there was a bill before Congress that would have adopted pilot programs similar to what was in the 2014 Farm Bill. That did not pass, but a state bill in Kentucky, Senate Bill 50, that authorized pilot programs passed in 2013. In 2014, the Farm Bill authorized pilot projects for industrial hemp. Kentucky, through its Department of Agriculture, issued licenses for the cultivation and sale of hemp pursuant to the 2014 Farm Bill. In 2018, again, the Farm Bill carved hemp out from marijuana and authorized the cultivation, manufacture, and sale pursuant to USDA-approved programs. In 2021, Kentucky's program that it had submitted to the USDA was approved for regulating the domestic production of hemp. Similar to most of the state-approved programs, Kentucky's USDA-approved plan really focused on the cultivation of hemp, on ensuring that the THC content of hemp was 0.3% or less at the time of harvest, and really did not focus on consumable products or hemp-derived cannabinoid products. Really, in 2018, people were thinking that hemp was going to either be an industrial hemp market, so fiber, manufacturing products, or CBD. And what has really happened is that the bulk of the market has very rapidly in the past 2 years been overtaken by hemp-derived cannabinoid products. And so many states, including Kentucky, are starting to wrestle with or change their regulations to specifically regulate those types of products. And Kristin's going to kind of talk to you about that.
Sorry, I was muted. Many of you all likely know this, but in early 2021, the Kentucky Department of Agriculture sent a letter to all licensed hemp growers and producers in the state that took the position that Delta-8 THC was illegal. And the Kentucky State Police raided several businesses and tried to press criminal charges against these businesses, including for trafficking in marijuana, for selling Delta-8 THC that was hemp-derived. In response to that, the Kentucky Hemp Association filed a lawsuit in Boone Circuit Court seeking an injunction to prevent the Kentucky Department of Agriculture and the Kentucky State Police from taking any further action with respect to that letter that was issued by the Kentucky Department of Agriculture, and also seeking what's called a declaratory judgment that Delta-8 THC in hemp-derived cannabinoid products was legal. And on August 3rd, 2022, the Boone Circuit Court issued an opinion in that case, finding that Delta-8 THC is a derivative of CBD, which is a derivative of hemp, and therefore Delta-8 THC is a derivative of hemp under Kentucky law, and that any products containing Delta-8 THC that is hemp-derived are legally compliant hemp under Kentucky and federal law. At that time, Delta-8 THC was not considered in Kentucky under the umbrella of hemp-derived cannabinoids, so it wasn't being regulated pursuant to the previous hemp-derived cannabinoid regulations. And in response to that circuit court order, on November 15th of 2022, Governor Beshear issued an executive order 2022799, that addressed the fact that at that time, Delta-8 THC was not governed by the current hemp-derived cannabinoid regulations. And those regulations were 902 KAR 45:190. So Governor Beshear's executive order ordered the Cabinet of Health and Family Services to regulate Delta-8 THC under that hemp-derived cannabinoid regulation. And so starting in November, Delta-8 was regulated under those regulations, but as I said before, those regulations were incredibly minimal. Stephanie, next slide. Then in the 2023 legislative session, so at the beginning of this year, Also, in response to the Boone Circuit Court decision and Governor Beshear's executive order, the General Assembly passed HB 544, which ordered the cabinet to begin the process of regulating Delta-8 THC and other hemp-derived cannabinoid substances. So essentially instructing the cabinet to create more robust regulations governing these products. HB 544 ordered the cabinet to promulgate emergency hemp-derived cannabinoid regulations by August 1st, 2023. And in relevant part, HB 544 required the cabinet to include the following in its emergency regulations. So they had to prohibit the sale or possession of hemp-derived cannabinoid products with intoxicating effects, which under the statute, they're called covered products. They are not called covered products in the regulations, and we'll get to that. To require retailers to keep covered products behind the counter, to establish a laboratory testing and approval process for contaminants and phytochemicals of a covered product, and then to establish packaging and labeling requirements for covered products. And on March 23rd, 2023, Governor Beshear signed HB 544 into law, which then of course triggered the regulatory process and required the cabinet to start developing these regulations and to promulgate them effective August 1st, 2023. But as you'll see, as we talk about these, the regulations are much broader than the initial requirements that were set forth in HB 544. On August 1st, 2023, the cabinet did promulgate these emergency regulations. And these emergency regulations became effective immediately. So even though they're entitled emergency regulations, they are currently in effect. There was an initial comment period on these emergency regulations that happened. It closed at the end of September. And then in mid-October, the cabinet issued amended emergency regulations, which are currently the version of the emergency regulations that are in effect. The emergency regulations they will expire by statute on April 27, 2024. So before that date, the cabinet will have to take further action with respect to the regulations to ensure that there are still regulations in effect as of April 27, 2024. And it is our understanding that before the expiration of the amended emergency regulations, the cabinet intends to promulgate replacement emergency regulations as well as proposed final regulations. And there will be a comment period for both the new emergency regulations that are promulgated in April and the proposed final regulations. So there will be more opportunity for public involvement in these regulations before the final regulations are finalized and put into effect, probably sometime in late 2024, early 2025. But as we understand it, this is what the cabinet intends now. That of course could change when we get closer to this coming April.
I think in addition, Kristin, the reality is that we are not going to know what the final rules that are going to govern the program are for some time, and that participants in the market are still expected to be complying or coming into compliance with these rules, despite the fact that they're emergency and subject to change over the next several months.
All right, so now we're going to talk about the actual requirements of the emergency regulations that are in effect currently. And to start, I think Arin is going to start talking about the types of cannabinoids.
Yeah, so the regulations themselves cover broadly hemp-derived cannabinoids. And within that broadly defined group of hemp-derived cannabinoids, you really have two kind of subsets. We'll start with the hemp-derived cannabinoids are defined as anything that's aimed at human use or consumption. So as Hannah mentioned earlier, there was sort of the legacy hemp industry that was more revolved around industrial uses like rope. This is not aimed at that. This is truly for products that are going to be either ingested or applied to human bodies. So within the hemp-derived cannabinoid regulation scheme, they're then broken down into adult use cannabinoids and non-intoxicating cannabinoids. Adult use are those that are defined as changing the function of the nervous system and resulting in alterations of perception, cognition, or behavior. So the way that these regulations were drafted is they were meant to be very broad and to encompass sort of the known intoxicating cannabinoids like Delta-9, Delta-8, THCA, but also drafted as sort of a catch-all that if there are future developments or discoveries into other cannabinoids that might have psychoactive effects, that those are covered by these regulations as well. And the regulations themselves kind of emanate, as Kristin said, from the statute that was passed by the legislature and signed by the governor. And that explicitly calls for kind of this broadly defined regulation over all intoxicating cannabinoids, and not just focusing on the more popular ones like Delta-8 and Delta-9. So that's one group. And then on the other side, you have what they call non-intoxicating cannabinoids. And those are really defined as just basically the opposite. So anything that does not have, that does not change the nervous system or result in alterations in perception, cognition, or behavior. Now within that, there's sort of a question of, okay, well, what happens if products contain both an adult use cannabinoid and a non-intoxicating? And there, the current regulations, emergency regulations as they stand, apply a 25-to-1 ratio. So you have to have 25 non-intoxicating cannabinoids to 1 intoxicating. And within a product that to meet that ratio, it also has to have less than 2.5 milligrams of an intoxicating cannabinoid per serving to still be considered non-adult use. Now, this doesn't, as we'll get into, this doesn't necessarily mean that those products are not allowed if they exceed that 25-to-1 ratio. It just pushes them into the category of being adult use, which then changes how they're treated under the regulations. And to touch on that, we'll get into the more specifics, but a couple of areas where this matters is, for example, packaging. Packaging as it relates to adult use products. There are different requirements for those than there are for the non-intoxicating. So before we go on to the next slide, one question we generally get more broadly around these regulations, and we start talking about cannabinoids, and in particular, products that meet the definition of hemp and are less than 0.3% THC, Delta-9 THC on a dry weight basis. It's kind of how can the federal government do this? How can they be stepping into this space and regulating? And it's sort of a complicated question. For starters, there is language in the Farm Bill that does authorize states to issue regulations. But if you take a step back from that and you look at a question of, this is really a question of preemption, to use sort of a lawyerly word here, but the federal government can preempt state laws completely at times. And this will happen in some areas like immigration law or patents and copyrights. But usually the default is that federal laws and state laws are meant to coexist. And federal laws are really meant to set a floor and a baseline for conduct, and states are kind of free to go above and beyond that. An example of that might be with the minimum wage laws, where the federal minimum wage is $7.25, but you go to a state like Ohio, it's over $10. So even though the federal government has stepped in here, it is possible that the states have some role to play. And as Kristin will talk about later, that's subject to litigation right now. So the exact line of where the federal government ends and the state line begins is yet to be determined. Next slide, please.
Before we talk about the permitting and registration requirements under the emergency regulations, we got a quick question about what was the emergency, meaning why did we have to have these emergency regulations. And I think that there were two things going on based on the language of HB 544 and also the language that is in the emergency regulations. So in HB 44, the General Assembly stated that the Commonwealth and the General Assembly have an interest in limiting the ability of minor children to obtain Delta-8 THC products and other products that have intoxicating effects on consumers, and ensuring that adult consumers of such products have access to accurate information about their contents. So that was one of the emergencies this was addressing, was the fact that at least before these emergency regulations went into effect, minor children could purchase Delta-8 THC products or other hemp-derived cannabinoid products with intoxicating effects, which is believed to be a public safety risk to children. And the emergency regulations also state that the purpose of the emergency regulations is to ensure that all hemp-derived cannabinoid products produced and sold in the state are safe for human consumption. So that is the emergency that these emergency regulations were addressing, and was why the cabinet was allowed to promulgate emergency regulations rather than having to just go straight to promulgating final regulations. The emergency regulations require that any person located in Kentucky that is seeking to process, manufacture, store, or distribute hemp-derived cannabinoid products shall be permitted by the cabinet. Hemp processors and manufacturers in Kentucky were already permitted, but they were permitted under the food processing regulations rather than under the hemp-derived cannabinoid regulation. So now that permit is moving under the umbrella of the hemp-derived cannabinoid products. On top of Kentucky manufacturers and processors, all out-of-state processors and manufacturers of hemp-derived cannabinoid products that are available for distribution in Kentucky are required to submit an annual registration to the department. The regulations go through what out-of-state processors and manufacturers are required to submit with their registration. That includes a copy of their permit that's issued from the state that they are in, a copy of the state regulations that apply to that processor or manufacturer, as well as if they're selling an adult use cannabinoid product or processing or manufacturing an adult use cannabinoid product. All adult use cannabinoid products require a $200 registration fee per product under the regulations. The regulations also require registration for non-intoxicating hemp-derived cannabinoid products, but those don't have a registration fee. Finally, retail establishments and food service establishments that offer adult use cannabinoid products for sale have to register with the cabinet, and there's a link in the emergency regulations through which retail establishments and food service establishments can register with the cabinet. It's our understanding that the cabinet is going to be publishing a website for processors and manufacturers to register with the cabinet, and that's also how the product registrations will be done. All of that will be submitted electronically through the website that the cabinet is going to be putting out. Next slide, Stephanie.
Okay, so as it relates to packaging and labeling, the regulations call for all packages, no matter whether they're adult use products or non-adult use, to comply with Section 4 of the Fair Packaging and Labeling Act, which is a federal law that speaks to how quantities are declared on packages. Within the regulations themselves, also with respect to all products, they must all come in tamper-evident seals. So the packaging, even for non-intoxicating products, tampering must be evident via the packaging. And with respect to the adult use products specifically, they need to be in child-resistant packaging. So the way the regulators define that is a child-resistant package is something that makes it significantly difficult for children under the age of 5 to open. And if it's a product that's more than a single serve and it's meant to be used multiple times, the packaging itself needs to keep its child-resistant properties with each use. So if you all are familiar with state medical marijuana and adult use cannabis programs in other states, these kinds of regulations have been around a long time. There are a lot of packaging options that are out there for these products. With respect to then the labels themselves, there's a lot of kind of what can't go on a package. So things like cartoon images, anything that's meant or that could be appealing to children, the word candy or candies, or any type of design that makes the product kind of look or feel or imitate like any commercially available candy, snack, baked goods. So we've seen this in throughout the hemp market, as well as the broader cannabis market, where some products have taken names that are very similar to commercially available products. So instead of Skittles with an S, it's Skittles with a Z. And these regulations make clear that products like that are not permitted. The idea being that they could be confused or appealing, confused for the non-hemp products, or possibly appealing to children. The other thing that cannot be on a package is any sort of implicit or explicit health claims that the product can diagnose, treat, cure, or prevent any particular disease. This is something that is a concept that's been around for a while in the broader cannabis market and can become quite complicated in terms of where that line is. But it is something that these regulations have explicitly said they do not want to see health claims. In terms of what needs to be on the package affirmatively, there must be sort of a common cannabinoid description that's in font that's larger than the same size or larger than the actual product name. Meaning, if it's a primarily Delta 8 product, it needs to say Delta 8 THC gummies or whatever on the front, so that whoever's purchasing the product knows kind of what the primary cannabinoid is in there, and it's very obvious from the packaging. For adult use products specifically, there's a very long list of warning statements that must be on packages. I won't bore you by reading all of them, but for example, one of them is this product is intended for use by adults 21 years and older, keep out of the reach of children. There may be health risks associated with the consumption of this product. And then there's about 7 of these that must go on the package. Obviously, putting that much text on certain packaging is not feasible. So the regulations have allowed for, instead of putting those warnings directly on there, using a QR code that consumers can scan to then see the warning statements. Next slide, please.
One thing to note is Arin's going to talk to you a little bit about later on about trends we're seeing in states across the country. And Kentucky really is one of this group of first states that are kind of adopting a much more highly regulated system for the production and sale of hemp-derived cannabinoid products. But much of the many of the regulations are being pulled from existing state marijuana programs. So folks like Arin and I, who have been practicing law in the state legal marijuana space for years, are very familiar with many of these kind of regulations, because they are pulling directly in many cases from state marijuana laws.
Yep. And in some cases with these regulations, if you Google the exact language, you'll actually find other regulations and laws in other states where it's literally copied verbatim. So as it relates to the testing requirements, this is a really large focus of the regulations themselves. So if you actually print out the regulations, about half of what you're looking at are the testing regulations. The idea of it being that the regulators want to ensure that products are safe, that consumers know what they're getting, and also that there's consistency within the products so that people don't have unfortunate experiences if products are inconsistently dosed. In terms of what must be tested, it's each batch or a lot of a particular product. And what this effectively means is that anytime a production run is made of a product, that must be tested, and it must be the equivalent to the final product that's going to be consumed. So if you're making chocolates, it's sort of the final chocolate must be tested each time you run a lot or a batch of that. In terms of the regulations get very specific around kind of sample sizes and things of that nature. So the sample size must be large enough that the various tests can be performed, as well as tests to ensure that it's consistent throughout the batch itself. So it's got to be sufficiently large sample size that you can determine that. The processor or manufacturer who sends in the sample to be tested must maintain a backup sample for 2 years, and it must contain there's corresponding numbers that go onto each batch, that it must be correspond with the batch that's then, or the sample that's then retained, and also the final products themselves must have those numbers associated with them so that products can be traced, and if there are any issues subsequently, that it's easy to determine which products came from which batches. The labs themselves must be independent and be ISO certified. They do not necessarily have to be in the state of Kentucky, but if you're selling in the state of Kentucky, these regulations must be complied with. And also for anyone who's manufacturing and testing products here with the intent to ship them out of state, they must also comply with these requirements unless the state that's receiving the products, the ultimate destination, has testing regulations that are comprehensive and similar to Kentucky's. So in terms of what's actually being tested, there's kind of the big categories that I'm sure most of the people on this call are familiar with, but it's things like the cannabinoids themselves, microbial impurities, pesticides, heavy metals, solvents. And each of those categories has very specific regulations around the parts per million of various types of products that can and cannot be in there and what the limits are. If any of these tests fail, so if a batch fails, it can be immediately retested. If it passes a second time, then there needs to sort of be a confirmatory test done by another lab. So with the same lab, one passed, one didn't, they need then a third party, another third party lab to verify that it is safe to be consumed. If a particular batch fails, depending on why it failed, sometimes a particular lot can be remediated. For example, if some of the solvents can be removed by reprocessing, then those can be remedied and then retested before being sold. Next slide, please. All right, so in terms of the sales of the products, one of the things that HB 544, so the actual statute, makes very clear, and that statute is very short, it doesn't get into much, but two of the issues it does address are who can buy these products and where are they in a store. And HB 544 says that people under the age of 21 cannot possess, gift, sell, or otherwise transfer, purchase intoxicating adult use products. The statute also says that the products themselves must be behind a counter in order to prevent theft or easy access by children. The regulations go into slightly more detail and say that the products must be secured. What that means at this point is unclear, but there needs to at least be some attempt made to secure these products within a store and keep them out of the reach of children. The products themselves, if they are adult use, can only be sold to people who are over 21, and IDs must be checked for that. Non-intoxicating and cosmetic products can be sold to people under the age of 21. And I know we did get a question earlier related to whether products can have more than 2.5 milligrams of hemp-derived THC, and the answer is yes. So sorry if I wasn't clear on that earlier. It just means that if a product has more than 2.5 milligrams of an intoxicating cannabinoid, it makes it an adult use product, and therefore these age restrictions apply. If it has less than 2.5 milligrams per serving, then it's considered a non-intoxicating. And so a product that, for example, had 25 milligrams of CBD and 2.5 milligrams of THC, that would be non-intoxicating. It could be sold to someone under the age of 21. And the last thing I'll say just about the age restrictions is that there's the age restrictions at the retail level, but there's also age restrictions in terms of processors, manufacturers, and warehouses, that anyone under 21 and over the age of 18, they can work there, but they have to be supervised by somebody over the age of 21. If they do not have an over 21 supervisor, then they're not permitted to be employed there.
One thing, I think this is a good point to kind of remind people that these regulations are new to the state of Kentucky, that there are some inconsistencies between the language in the statute and the language in the rules, and questions about kind of what exactly is required. And operators, regulators, lawyers, everyone for the next little bit is going to be working out kind of exactly what does this mean operationally. So for example, if you have in your particular retail location a way that you want to be displaying these products and don't know if it complies, there's certainly room here and at this time to be going to the regulators, working with the regulators to see if there is a way for your existing layout or what you want your products, how you want your products to be displayed, seeing if there is a way to have it so that that particular layout or display complies.
Okay, so the next slide, please, Stephanie. The regulations do allow specifically for internet sales and direct to consumer sales of hemp-derived cannabinoid products. Any retailer selling products in Kentucky through internet sales must also register with the cabinet. So the retail sale portion of the regulations also applies to internet sales. As Arin was kind of just touching on, all retailers selling adult use cannabinoid products to consumers, including through internet sales, must obtain proof of age of the buyer to verify that that buyer is 21 years or older. On a website, that looks different than it does in a store. So often on a website, I'm sure you all know, you'll see that you have to verify that you're 21 years or older. You click a button before it allows you to go into the site. And then retailers may deliver or ship adult use cannabinoid products to consumers 21 or older in packages that are clearly marked adult use only. We've gotten a question about why internet retailers are allowed to sell hemp flower direct to consumer in Kentucky, but retail stores are not. And to be clear, Kentucky does not allow the sale of hemp flower direct to consumer. Hemp flower can only be sold in Kentucky to a licensed processor or manufacturer. The issue, of course, is that internet retailers are not allowed to sell flower direct to consumers in Kentucky. But of course, the problem is that just because the regulations prohibit it doesn't mean that there aren't internet retailers that are selling flower direct to consumer in Kentucky. That issue falls more under the category of enforcement than it does under the category of what is allowed by the regulations. But just to be clear again, no one is allowed to sell hemp flower direct to consumer in Kentucky, including internet retailers. So if they are doing that, that is in violation of Kentucky law. Also, I got a question about the website for product registration and out-of-state processor and manufacturer registration, and when that's going to go live. We don't know when it's going to go live. Our understanding was that as of mid-November, the website had been built, and it was going to go live in the next few weeks. As far as we know, it hasn't gone live yet. Currently, under the emergency regulations, out-of-state processors and manufacturers are required to register with the state before January 1st, 2024. So hopefully the cabinet is going to get that website live as soon as possible so that that registration can occur. Next slide. Under the emergency regulations, hemp-derived cannabinoid products can only come from an approved source. And an approved source under the regulations means a Kentucky hemp grower or handler licensed by the Kentucky Department of Agriculture, or an out-of-state hemp grower or handler who is duly authorized to produce hemp under the laws of the applicable jurisdiction. A hemp product manufacturer or processor with a permit from the Kentucky Department of Public Health, or a manufacturer or processor with a permit from another state regulatory authority for hemp-derived cannabinoid products. If that state has been approved by the department, and by the department here, it means the Department of Public Health or the Cabinet for Health and Family Services, as having equivalent state standards for processing, laboratory testing, and labeling requirements. So to be clear, not all out-of-state processors and manufacturers will be able to register in Kentucky for its products to be available here. The only manufacturers and processors from out of state that will be allowed to do so have to be from a state that has regulations in place for the manufacturing and processing of hemp-derived cannabinoid products, and that processor or manufacturer has to have a permit. And our understanding is that the reason for these requirements is for enforcement purposes, because the Cabinet for Health and Family Services in Kentucky will not be able to monitor and enforce these regulations against out-of-state processors and manufacturers. Processors and manufacturers may not treat or otherwise adulterate a cannabinoid product with any non-cannabinoid additive that increases toxicity or addictive potential that excludes caffeine. But it includes alcohol, nicotine, or other chemicals that may increase carcinogenicity or cardiac effects. And there's a list in the regulations regarding, so this list is in the regulations, and there's also a list in the regulations about what hemp-derived cannabinoid processors and manufacturers can use as solvents. And also what substances are prohibited in hemp-derived cannabinoid extraction. So that includes acetates, medium chain triglycerides, polyethylene glycol, etc. Next slide, Stephanie. The regulations do have a section specifically about enforcement. So the Cabinet of Health and Family Services and its authorized agents are required to conduct on-site inspections of all hemp-derived cannabinoid processing and manufacturing establishments, storage warehouses, distribution centers, and other retail establishments that offer adult use cannabinoid products. So this is what the regulations state. To be clear, it's our understanding that active enforcement is not currently happening right now. So as Hannah alluded to earlier, These regulations are new, and everyone from operators to the regulators are in a place of trying to work towards compliance. So it's our understanding right now that the cabinet is not actively taking any measures to inspect unless they get a report that a hemp-derived cannabinoid processor, manufacturer, or retailer is in violation of these regulations, in which case they will have to take enforcement measures of some sort. The cabinet is also allowed to inspect retail establishments that offer only non-intoxicating cannabinoid products if they receive a complaint or report of a serious adverse event or at the cabinet's discretion. If the cabinet finds that a permit holder is in violation of the regulations, then the permit holder has to take immediate steps to correct the conditions that have caused an imminent health hazard. And if the operator fails to do so, then the cabinet is required to suspend the permit or the portion of the processing or manufacturing operation that's affected by the imminent health hazard. And if a permitted facility has a suspended permit twice or more in a 5-year period, then the cabinet has to initiate proceedings to revoke that permit. Outside of enforcement from the cabinet for health and family services, there are also other risks to hemp-derived cannabinoid processors, manufacturers, and retailers. There could be consumer protection actions that are undertaken by the Attorney General against retailers or processors or manufacturers. There could also be potential civil liability. For example, in California, there is currently a lawsuit pending regarding hemp processors and manufacturers that are selling high THC hemp products, and that those products are essentially interfering with the sale of cannabis and should not fall under the category of hemp, but technically are cannabis and thus are in violation of the laws of California. And then there could be potential federal liability depending on the exact violation that's being done by the hemp-derived cannabinoid processor or manufacturer. And then specifically with respect to regulations of hemp-derived cannabinoid products, and as Hannah talked about earlier, the Farm Bill sets, and Arin talked about this, the Farm Bill sets a baseline regarding hemp-derived or the sale of hemp. There have been actions filed in multiple states that challenge regulations that restrict the sale of hemp or the creation or sale of hemp-derived cannabinoid products beyond the requirements of the Farm Bill, arguing that the Farm Bill preempts those state regulations. And to date, there's been a split amongst courts that are dealing with those actions. So, for example, a federal court in Arkansas ruled at the preliminary injunction stage that the plaintiffs in that case were likely to succeed on the merits of their claim that Arkansas's ban of synthetically produced hemp-derived cannabinoids is preempted by the 2018 Farm Bill. Meanwhile, a federal court in Virginia denied the plaintiff's motion for a preliminary injunction regarding Virginia's law that imposed a limit on substances containing THC according to the concentration of total THC rather than the concentration of delta-9 THC as defined in the 2018 Farm Bill. So there's currently an open question about the interplay between the 2018 Farm Bill and these state regulations and how far states can go in regulating these products beyond the requirements of the Farm Bill.
All right, so we're running a little short on time, so I'll go a little faster here, but trends in state regulations. So if misery loves company, then there's plenty of misery to go around right now because a lot of states are currently regulating or outright banning hemp-derived products. As Hannah mentioned earlier, there was sort of a waiting period after the Farm Bill was passed where we thought the FDA was going to take action and regulate CBD and other cannabinoids, but they didn't. They were concerned about the health effects of CBD and whether it had issues on liver, male reproductive system, other issues. And so they kind of punted it and said, Congress, you deal with it. The states since then, and also slightly before that, have really stepped up in a big way. So while the states more or less sat by for the first few years after the Farm Bill, it's really within the most recent 12 months that this has really become a very rapidly changing area of state law. And in a way the speed is really quite unprecedented in how quickly states are jumping in and passing regulations on this. So generally there's kind of four ways that states have stepped in. One is they've just done nothing. So they've yet to regulate it. Another is they've outright banned the products. Some states, they have a comprehensive regulation scheme like Kentucky, and other states have said, okay, we're going to regulate this under our existing state cannabis programs. So medical marijuana or adult use marijuana. So we've seen kind of those four ways that states have addressed this. Those are very broad. It's really more of a spectrum than necessarily they neatly fall into one of these buckets. For example, in California, Delta 8 is regulated as part of its state legal cannabis program, but Delta 9 has its own regulatory scheme. So this is a rapidly changing area, and I think to the extent that folks are frustrated with Kentucky and looking to move elsewhere, I think my advice would be hold tight, because this is all changing very quickly. And to the extent that you all have questions about what's happening in other states, Dentons does monitor all 50 states and keeps a 50-state survey active and current at all times. So we have a very good knowledge of kind of what the national landscape is, if anyone has any questions about that.
Next slide. So I have a really short period of time. I'm gonna, Stephanie, tell me if I can't do this, but I'm gonna present a little bit over. Folks are welcome to hop off or they can follow up. I'm gonna try to keep it brief, but I do want to talk to folks a little bit about kind of perspective changes in federal law. And if you go to the Kentucky Department of Agriculture's homepage on regulation of hemp-derived cannabinoids, there's a statement that says license holders investing in this early stage in the industry should be aware that federal law is subject to change, that there is uncertainty at the federal level on what part of the hemp plant can be lawfully sold. And it is true that there is a lot of unknowns, and there is likelihood that we are going to see changes in federal regulation of hemp-derived products in the next year to 2 years. And where we're going to see those changes is from Congress, either from the reauthorization of the Farm Bill, which has been pushed out to 2024, or standalone legislation, through Drug Enforcement Agency, or from the Food and Drug Agency. Stephanie, can you move to the next slide? So for Congress, you know, they could potentially make changes to how hemp is regulated in the Farm Bill. I think right now the thinking is that it is unlikely, although it is possible, that the Farm Bill is not going to address hemp-derived cannabinoid value-added consumer hemp products. And instead, the changes are going to really be focused on kind of the cultivation of hemp. And the changes that we think might be in there is there may be an increase in the 0.3% threshold on a dry weight basis at the time of harvest to 1%, to address concerns that have been raised by hemp farmers across the country. That 0.3% is a really hard metric to meet, and that they've had to unnecessarily destroy crops because they're hot hemp. We also think that there may be a change in kind of the requirement that testing labs have to be licensed by the DEA. But it is possible that even if the Farm Bill doesn't address hemp-derived cannabinoids, that Congress could step in and separately address them. And there's a few things that Congress could do. They could make no changes. If they make no changes, then we'll stay in the place where we are, where the FDA says we don't think we've got the authority to regulate this under the current laws that we operate under. And really, it will become a patchwork of states banning, states regulating, states running it through their cannabis program, that the regulation will be left to the states. They could potentially kind of clamp down on what is perceived to be some of the loopholes in the 2018 Farm Bill and could, for example, prohibit intoxicating hemp-derived cannabinoids. There was a bill from House member Shelley Pingree, who sits on the Agricultural Committee, that would have banned intoxicating hemp-derived cannabinoids. That bill didn't go anywhere, but there's a possibility it could be reintroduced in the future. They could also kind of broadly liberalize federal hemp policy. They could clarify that certain intoxicating cannabinoids are legal under federal law. They could increase the Delta-9 THC percentage in hemp and then not impose any additional regulations. They could also liberalize hemp policy, but mandate increased regulations for, by example, directing the FDA to add to regulate certain categories of hemp-derived products. Next slide. So we could also see a change from the Drug Enforcement Agency, and this could come through guidance or clarifying rulemaking. It could come through enforcement. So, for example, earlier this year, the Drug Enforcement Agency issued guidance saying that it is their opinion that cannabinoids that do not naturally occur in hemp, but are manufactured from cannabinoids that are naturally occurring and derived from hemp, for example, specifically THCO, which doesn't occur in the hemp plant, but is manufactured oftentimes from CBD, that is a synthetic cannabinoid, and synthetic cannabinoids are a controlled substance. So even though it is manufactured from a product that's coming from hemp, it's the DEA's position that it's not hemp. The DEA could potentially expand that position through rulemaking to, for example, say, even if a product is naturally occurring in hemp, if it is not derived directly from hemp and instead is manufactured from another hemp-derived cannabinoid, that product is a synthetic THC and therefore a controlled substance. So, for example, Delta-8 occurs naturally in hemp, usually in low levels in order to kind of scale to commercial production. Delta-8 is produced from molecular changes to CBD that's derived from hemp. The DEA could take the position that any Delta-8 that is produced from CBD is synthetic and therefore illegal. Next slide. Stephanie, thank you. So also we could see increased enforcement from the Food and Drug Agency. Again, it is currently the FDA's position that is a violation of federal law, Food and Drug and Cosmetic Act, and this has civil and potentially criminal penalties to introduce into interstate commerce consumable products that contain Delta-8, Delta-9, and hemp-derived CBD. Or it is possible that the Food and Drug Agency could adopt regulations. This would likely have to be pursuant to a mandate from Congress. Congress would pass a bill directing the Food and Drug Agency to develop regulations because as we discussed this year, they came out and said, we have concerns about potential health risks associated with CBD in particular. We don't think we can safely regulate the products under the current framework. I think that there is how federal law could change might depend on the product type. When I think about hemp-derived products, I think about them in three buckets: non-intoxicating CBD consumable products, synthetic hemp-derived THC products, and then psychoactive products. There is a push right now to have Congress direct FDA to either classify non-intoxicating CBD consumer products as a dietary supplement and regulate them using kind of the regulations for dietary supplements. So pre-marketing notice, label and packaging, disclaimers and warnings, manufacturing and testing, or to create a new class, but use similar regulations that people are saying, look, dietary supplements pose similar kind of risks. You have determined that you have the ability to control or mitigate those risks through regulations in place for dietary supplements. You should be treating CBD the same way. I think that it is much more likely that these synthetic cannabinoids are going to be banned or determined to be a controlled substance. And the real question is, what is the federal government going to do, or are they going to do anything with the psychoactive hemp-derived cannabinoid products? So I think we're all happy to talk to anybody offline. I know that there are a bunch of questions that we didn't get to. We had a short amount of time today, but it was an absolute pleasure to be able to present to you all on what is a really kind of interesting topic. And I expect there to be, both in Kentucky, in states across the country, and at the federal level, meaningful changes to kind of these regulatory regimes on an ongoing basis in the coming years.